the things I do for the firm is I'm involved a lot with creditors' rights work. Also work in and out of bankruptcy courts. And kind of the confluence of those in this case would be privileges and liens, both here in the state of Louisiana and also in Texas. Here in Louisiana, we're going to kind of give you a little overview of the Louisiana's Oil Well Lien Act. And so I'll try not to get bogged down too much in technical or in statutory language. And numbers, though you'll see them on the slides. And for those of you who don't have one, there are copies of our presentation on each table, or several of the tables, and please do pick up any. Also, please feel free to ask questions. Since it's a small group, let's keep it fairly informal. And you know, if you have a question, something you don't understand, or maybe something you'd like us to elaborate on, be glad to talk to it. And certainly, if I don't know the answer, I'll ask Sam or David to tell us. So, with that, let's go ahead and talk a little bit about the Lien Act. As Sam said, a lien is like an encumbrance or mortgage on a piece of property for an oil field service company that is owed money and it's unpaid. This is a device that you can use to get the attention of the company that owes you some money, oftentimes quite well and quite quickly. But it's there are a number of rules that have to be followed, and it all turns on a timeline that anybody employing a lien needs to keep in mind.
If I could, one of the advantages of the lien, of course, is you're going to separate yourself from other ordinary trade creditors. Because if you can file and perfect a lien, you're going to be a secured creditor rather than an unsecured creditor. And we all know in troubled times like this, when folks are having trouble paying their vendors, their materialmen, or if they go into bankruptcy, you want to be a secured creditor and not an unsecured creditor. And that's really what this is all about.
Yeah, there are kind of three numbers, I guess you might say, that I'd keep in mind. The first is 180 days. And that's the length of time that you have, or that a provider of well goods and services has within which to file a lien. And that time starts ticking at the last provision of goods and services to the site. That same timetable applies to notice that a lien is going to be asserted. Notice has to be given to the operator of the well. And once that lien has been filed, there's a 1-year period within which to take action on the lien. An action to preserve the lien in that case would be a lawsuit. After you filed your lawsuit, you have 30 days within which to file what we call a notice of lis penens. I should say that a lien arises, you may not realize it, but you actually have a right to a lien if you're a supplier that arises on the first day you begin providing goods and services to a well site. And you're just, by filing it within 180 days, what you're doing is you're putting the world on notice via a filing that you make in the mortgage records of a parish to your claim of privilege. So you might say that you have perfected it at that point, and it's allowed to continue on for another year, up to another year, before you have to take additional action in the form of enforcement.
As a practical matter, we usually do the first two things together. You file your lien or privilege in the mortgage records of the parish in which the services are provided, where the well is located. And if it's an offshore parish, an offshore well, whether it's state water bottoms or federal water bottoms, we file the lien in the landward adjacent parish or parishes. Often when you're working offshore, you'll need to file the lien in 2 different parishes. So the lien gets filed, and then a certified copy of the lien gets presented to the operator. All of that has to happen within 180 days, and that takes care of your first 2 requirements.
Might add, if it's offshore, you also want to file
With
a copy with
vestige.
With
You'll also
Bessie.
file with Bessie. And then, to maintain the privilege, you must file an enforcement lawsuit within a year. The lawsuit is generally gonna be filed in the parish where you filed your lien. There could be exceptions, but that's always a safe place to file your lawsuit. And at the same time, you should not wait that 30 days. The day you file your lien, your lawsuit to enforce the lien, you ought to also be filing your lis pendens. And again, that's filed in the mortgage records of the parish where the well is.
What, for everybody, what a lis pendens is it's a separate filing that you make in the mortgage records that basically tells anybody who searches those mortgage records that in addition to your claim of lien, you have filed a lawsuit enforcing that lien. So if I look at the mortgage records and I see not only a lien, but also a notice of lis pendens, I know that there's a live dispute out there, and I should, that can be useful, and it's essential actually to preserving your action on the lien.
Can you clarify for a well in federal waters where the lien should be filed?
What you want to do in federal waters is you're going to want to file in the parish or parishes nearest to the well site. Okay.
How is that determined?
Well,
There are actually some maps that were produced by the old MMS. I suspect there's more current maps coming out of Bessie now, but you can get maps through Bessie that show the parish lines at the coast. And, some of them are running straight, some of them run like this, some of them run like that. And it's really kind of a best guess, it's not a science. But you project those lines into the Gulf. And then if it's close, generally you'll fall in two parishes. But there are some circumstances where when you get to southeast Louisiana, where you could possibly fall in three parishes.
yeah,
There's really no case law or litigation about that. You just want to be conservative and cover your bases. Doesn't hurt to file a lien in an extra parish. You're not going to be damaged by that.
that's cheap insurance. So I would definitely err on the side of additional filing. When you look at privileges, there's different classes of people who are eligible to file privileges. And this slide gives you kind of a rundown of who might do so. But I think generally you could summarize it by saying anybody who's providing goods or services to the well site itself. And, for those folks who are like in the engineering business, consultants, this sort of thing, if you're in direct privity with the operator, if you're providing goods and services to the well site, and we see liens filed all the time on that. Yes, sir.
Where is the best place, consolidated place to look to see if a particular well has any liens filed against it? And is there a particular place, is that also the same thing, where you can search to see if somebody you're doing the work for has liens filed on their other wells?
Perfect question. What you're going to want to do is you're going to want to look. Louisiana's got a number of parishes have online record search ability. Certainly law firms can help you out on that. We'd be glad to. But you would look in the mortgage records of the parish where the well site is located. And, as far as checking on, additional wells that might be run by the operator, I would look on Sonorous and do a quick check to see where production is for XYZ, and spend a little time and see are there a lot of liens floating around out there.
For those who don't know, Sonorous is a online website from the Department of Natural Resources, state of Louisiana. You can take any operator's name. You can determine there's an operator number assigned to each operator. When you get the operator number, then you can do a search in the state and determine what wells they have that are producing and what other wells they've drilled. You could do, if you're concerned about kind of doing financial due diligence on this company, you might go back 24 months, 36 months, see what wells they've drilled, and then you could do, let's say they drilled 4 or 5 wells in Terrebonne Parish, then you look at the Terrebonne Parish mortgage records, and you can determine if they've got a history of lien problems or not.
In your experience, how delayed is the information in Sonorous?
It's about mortgage records in all the parishes will be very current, usually within 48 hours,
Tops.
24 hours. The mortgage records are up to date throughout the state generally. And then what's not online, they even have what's called an in-basket in most of the parishes, and you can ask them, what mortgages or what liens are in their in-basket, and bring it down to the minute that you do the check. But the state says it's a little more behind.
I think this is an opportune time to say that when you are searching on a particular site, it's important for you, if you're providing goods and services to a well site, to know as much as you can about that well site. There might be a dozen different operations in a given parish, and sometimes we'll see liens filed against one well, but not against any others. And so on the front end of your work, understand where you're going, get your well identifiers in hand so that you just need them. It's a good matter of business.
You can make it part of, if there any, you're taking credit at as a service company, and you're dealing with a company, an exploration company that you don't have a prior history with, you don't know much about, it's probably a worthwhile check.
Thank you.
What does it cover? Well, a lien discovers or covers not only the amount that you are owed, but it also will cover interest on an amount of money that's owed, as well as the cost of preparing the lien documents and reasonable attorney's fees. So, interest might be at a legal rate if you don't have it stated on your invoice or your terms and conditions. And I think, what's the legal rate right now? 4%? About 4%.
But if you have an MSA or invoices that charge 1.5% per month, that's going to be covered by your lien.
So that's an important thing as well. The cost of preparing the documents, that's going to be your filing fees, this sort of thing, and attorney's fees not to exceed 10%. Is also a nice thing to have if you're having to go to the mat on a collection matter. What does it cover? Well, there's a whole list of things here. I think the important thing, from my perspective at least, that it covers, in addition to movables on the well site that are intended to remain there, not talking about leased or rented stuff, but fixtures to the well itself. It covers the lease. Okay, that's an important thing, because it not only covers the well that you might have provided goods and services to, but the lease on which that well is situated. So what can happen is you've got a situation where there might be a dry hole in one site on a given lease, but 2 or 3 other wells are producing by that operator on the same lease. A lien filed against the non-producing well extends out to attach and mortgage the production proceeds from these other producing sites. That's why it's a very powerful tool.
A lot of service companies, a lot of service providers in the industry have the impression that, I provided $200,000 of services and equipment to that well, but it was a dry hole, so I'm screwed. There's no production, I'll never get my money. But if the well was drilled on a lease or a unit with other producing wells, even if you did not provide services to that other producing well, your lien actually extends to that production in that well. So it's a very powerful tool. The other thing to note is we talked about the lien is on the operating interest of the well, or the working interest. That means the lien does not encumber the landowner's royalty or any overriding royalty interest that might be on the well. So for instance, if the landowner has a 20% royalty, could be a 25% royalty, and the generating geologist maybe have a 3 or 4% override. Let's say the royalty and override adds up to 25%. Your lien is on 75% of the production. The royalty, the landowner royalty, who's an innocent party, and the overrides who aren't involved in not paying bills because it's a cost-free interest. The lien does not affect their interest. So your lien would typically be against somewhere between 70 and 80% of the production from the well, but not 100% of it.
Just to clarify, that is just per field. Correct. If you have a non-producing and or just another producing district, that field, not where the operator is producing it under.
It's not field
It's to the
wide.
lease.
It's to the lease
Okay.
or the unit. We have voluntary and compulsory units that are created in Louisiana. The unit might be 3 or 4 leases.
And an additional question to that, that is, the lien is actually filed against the operator, correct? So if there's somebody else that went together and they decided to form a group to form a project.
Right.
And there is a different operator, that lien is against the actual operator?
Well, technically, it's in REM, so technically the lien is filed against the property,
It's against the lease, you serve the operator.
but you serve the operator.
And while we're talking about service, you know, I mean, this is like a big stick of dynamite here. Lighting the fuse on that is when you deliver a copy of the filed lien to the transporter of the purchaser of production from that site. Because the first thing they're gonna do when they see that, if it's the first lien that's come onto the property, is they're gonna suspend payments. And, yeah, you wanna see things happen fast, that's when it does. Yes, sir.
What about following up on if there's no safety driveway and they're putting surface equipment up there, they don't have any other wells around it?
Not a good situation.
Then you're relegated to what in Louisiana and Texas both, it's called a suit on open account. And you're an unsecured creditor. You can't get to the posture of being a secured creditor at that point. But of course, you have contractual rights. And for instance, in Louisiana, the open account statute, you can file a lawsuit. You make a demand, you file a lawsuit, and you're entitled to collect interest and attorney's fees on that lawsuit. But, you know, you get a judgment. Actually, once you get the judgment, you can become a secured creditor, because then you have a judgment debtor lien. I mean, a judgment lien.
So what do you do nowadays, having a line when a company creates a new entity to drill a well, they have 0% of it, they're just
Contract operator? Well, that's the point that we were making. The lien is against the well. It doesn't matter that the contractor has a 5% working interest in the well, or he's a contract operator with no interest in the well. The lien is against the well and the property, and it burdens all of the participating working interest owners, whoever they may be. In fact, what we'll often see is $1 million AFE comes out. You got 4 guys participating in the well. They each put up their $250,000 for this contract operator who's going to back in after everything pays out. The operator takes the money and he spends some of it and pays some bills but doesn't pay all of it. Poor working interest owner, he's paid, they put up the $1 million, but if it doesn't get to the service company, you can still file your lien because the lien is against the well. And they end up, the exploration company in that is subjected to double payment.
But if the contractor's with the operator, he's got no percent, he's got some outside investment. We've been told you can't go after those guys, you know, go after the guys that have the contract.
On the suit on open account, that's a contract suit, so consequently, you can only sue the person your contract is with, okay? If you contract with broke dick operator, okay, your suit on open account is going to be against broke dick operator because that's who you're contract with. But if you provide services to the well and you file your lien within 180 days, you are going to be burdening the well and all of the working interest owners in that well. Now they're going to be upset with their operator, but you are going to have a lien against their property. That's why it's important to make the filing timely and to do it right.
This slide gives you a list of what's not included in the in any well lien, and essentially you're looking at rental equipment on site. You're talking about the landowner's interest, the overriding interest, We've already touched on that, but it's in the materials that I've got here. When is it established and when is it effective? I touched on it a little bit beforehand. You have a lien that's effective before you even file, and this is going to make the bankers squirm a little bit. It's what we call an inchoate right, and so you can go and you look in the mortgage records and there's nothing. There are no files, and everybody's thinking, okay, we can file this mortgage and we're going to have a prime position on the mortgage. Well, if 100 days before that mortgage filing, there were goods and services being provided to the well site. Maybe they haven't been paid, but there hadn't been a mortgage filed yet or a lien privilege filed yet. After the mortgage has been filed by the bank, the guy who's provided those goods and services can file a privilege and prime the bank's mortgage.
So what the bank has to do to protect itself is get a no work affidavit, which is essentially an affidavit from the oil company, and they do a little due diligence to confirm it. That nobody's been out there with the board well, first is your surveyor. He's going to be the first one out there. He's going to go stake a location for the well. Bulldozer operator's going to get out there and clear the well site, and then you're going to end up with board roads and mats for the drilling rigs before they ever come in. So what does the bank do? They want to make sure that well hasn't been staked, and you actually can do that by going online in Sonorous, and you can see if a permit's, the permit could be issued with the well not staked. So I guess that would not necessarily be, you can find out if a permit's been issued for the well, but you still would have to determine that the location had been staked by the surveyor.
If it's that big alone, go to the site. Take a look. That's what I would do. But the point here is that the privilege arises when the goods and services are first provided.
And it relates back.
And it goes back in time, yeah. And that's an important thing. We'll actually get to a point where that comes up in bankruptcy here in a little while. When does it extinguish? A lot of words there, but basically when the debt's paid, or when the parties agree that the debt should be retired and the lien should be canceled, or if somehow you don't follow the statutory requirements and either file timely or enforce timely or notify or file a list pendants.
And you enforce timely by doing what?
You enforce timely by filing your lawsuit within 1 year of the filing of your privilege.
What if you have an MSA that says we have to arbitrate, you can't litigate?
Well, the way you do that, is go ahead and you file your lawsuit to enforce, but you put a motion in front of the court that says, well, we want you to suspend the activity on this because there's an MSA that has a mandatory arbitration privilege in it, but we're doing this so we can comply with the statutory requirement that the enforcement action is made.
So even if you have an arbitration clause in your MSA or in your invoices, you still have to file a lawsuit timely and your list pendants. You're just going to ask the court to stay that lawsuit, those proceedings, until stay it pending the arbitration.
Now, sometimes what will happen is, you're intermittently providing goods and services to a well site. You're on site, you pull off, you remobilize, you go back, and so there might be a span of time, and you're worried, well, okay, I did this back in December. Do I have to measure 180 days from each time I pull off? Not true. You can, as long as there's no more than 90-day gap between your provision of goods and services to a site, it can be one privilege. So if you have a period when you're demobilized, you come back onto the site, as long as that's shorter than 90 days, you don't have to file a separate privilege for that.
Essentially, statutorily, you've got continuous operations as long as you don't have a 90-day gap in actual providing services.
We we pound on this a lot because, and you'll see some real world examples here in a little while, but liens, as good as they are, there's a lot of ways that they can die unnecessarily. You can do so primarily by failing to timely either file your lien or enforce it or file that lis pendens. And when it happens, the lien goes away and you're left, instead of having a claim of mortgage or a privilege on the property, you fall back to an open account status. And that's not a good place to be if there's a limited amount of money to spread among a whole lot of creditors. Notice to the well site operator is important. We talked about that just a minute ago. I mean, regardless of how much ownership they might have in the actual producing well, the statutory requirement is that a notice be provided to the operator within the same amount of time that you have to file the lien.
What if you have, the parties drilling the well have a joint operating agreement with, well, let's say they have a contract operator, and the contract operator isn't the operator, it's on Songress and recognized with the Office of Conservation operator.
I believe you go with Songress, but this is like the same situation as the coast. I would send them both.
Send it both.
You know.
So if you know that, ABC Exploration is the operator of record with the Office of Conservation, but you know that XYZ operator is the contract operator and running the operations for the well, maybe even the party that you contracted with, you're going to want to send it to the so-called contract operator and the operator of record with the Office of Conservation. Send notice to both.
I'm going to let David take it up. I need to get some water. But there are, I guess, the important questions here are what you have to say when you file a lien, and that's set forth in the statutes.
So the form that you want to use, it pretty much you're filing an affidavit attesting to stuff. So the service company will sign on behalf, attesting to everything and the documents being true. And so you're going to identify who the operator is. And in the instance that Sam was just talking about, you would identify both. And then really the most important thing is correctly identifying the lease and giving a general description of where the lease is located, why it should be filed in that parish. And important also is that you make sure you file it in the mortgage records, not the conveyance records, because the statute specifically says in the mortgage record. And then it's not, all it says at the bottom is, if you don't include the exact things that are required under the statute, it's not fatal as long as it fairly gives notice to the person.
I wouldn't dance under a knife, though. I think the issue there is make sure that on the front end that you know as much as you can about where you're delivering goods and services to identify the problem.
And one of the ways to make sure on the front end that you do this right is, and we see this problem a lot, we see sloppy invoices. And the invoices go out for services on a well. They may or may not have the well name on it. They may or may not have a field name on it. It's, well, we know where we sent it. It's the only work we're doing for ABC Exploration. It's in the, it's the Mamu field. Well, there's 60 wells in the Mamu field.
Would the well serial number or API number
Absolutely.
be?
Absolutely.
That's usually
that's
how
gold.
we identify it.
That's
in-
gold.
yeah, in
But
court
we
files.
we regularly see sloppy invoices. And they're okay to get your bills paid, but they don't help you when you go to file a lien, because you need evidentiary, you need kind of like a chain of custody. You need to be able to show that this invoice was for that well and for those services. And the best way to do it is to have the well name on it.
Let me make a point about this. I mean, it's not just invoicing. All these timetables, we talk about 180 days, it's from actual delivery, not from the day that the accounting department wrote the invoice, okay? So one of the things that we do, like sometimes we're called upon to defend an oil company against liens that have been filed.
Tax those
And,
delivery tickets.
And I make a chart that says how many days they claim in the lien it's been since the last provision of services. And I look at the invoices that sometimes are filed with the lien itself. If I see that invoice is real close to the 180-day deadline, I might want to know a little bit more about it, because it could be that the actual delivery was 10 days before and outside the deadline. So, you know, like.
Everybody's invoicing habits are different. Some people will invoice, yeah, and then, you know, they may realize they're up against the deadline, backdated invoice or something. So you look at delivery tickets too.
And those the same information that Sam's talking about on the invoices, the API number, the serial number, ought to be on the delivery ticket. So you can, you know, if you go in there and you can say, well, Joe signed this on, you know, the 5th of June, and we've got the ticket here to show it.
And just to give a real life example of that, me and Sam had a case where all they had on the invoice, I believe, was a date of work and a synopsis of the work. And what ended up happening, I did a search for that operator on Sunrise, and that operator no longer operated any wells in Louisiana. So we were kind of at a dead end to that point. And what they ended up doing is sending a worker out to the well, and he took a picture of the well placard and sent it to us. And by that, we were able to figure out who the current operator was. We served notice on the current operator and the original person that owed the money, and we were able to get paid by the new operator of the well. So, you know, it's really important to identify the well, so you don't have to take that extra time and that extra work on our part as far as extra hours of work. And just have your invoices state the exact date and a good synopsis of the work and the date of the actual work, not a date of the invoice. I think that's important also.
I'd also point out that the new operator had paid all of its bills, but the lien is against the well, not against any individual. So we were able to lien the new operator's well because we had provided services to that well. And if he had not paid the bill, the purchaser of the oil or the gas, whatever the production was, let's say Plains was buying the oil, would have sent notice to Plains and they'd cut off the cash flow. They'd be happy to hold money.
And that kind of ties into this, you know, if you give third-party purchasers notice, and they will withhold payment, and they seem to be overly cautious in our experience in withholding payment. And a lot of people don't know this. You can go on Sunrise and figure out which company is transporting hydrocarbons from each well, or, you know, from each collection tank from the well.
And that'll get anybody's attention. When the monthly checks quit coming,
Yeah, that's usually when we hear something after that notice. So as far as your privileges filed under LOLA, all of them will rank equally. And this goes back to what Army was saying about looking at your time periods and stuff. When we're dealing with a company that has a lot of privileges filed against it, we'll try to knock out some of the other privileges that were improperly filed, just so ours will you know, have a better chance of getting paid. And you can see at the bottom there, it talks about how it outranks all other privileges except, which is a pretty good list of the except, tax liens, pre-existing reported mortgages or vendors' privileges, perfected security interests, and liens by the Department of Natural Resources.
The pre-existing mortgages, again, the point there is that the bank can look at the records and think that they're all clean, but they still need to be sure that it's not been working and paid on the site.
in other words, if you do work in January and you file your lien in May, you know, the public record looks like, well, you didn't file until May, but it relates back to January, the day you first provided services. So that's the ranking for your oil well lien.
Is ranking also in the order that you do the lien, like you first?
No, all oil well liens rank equally. So for instance, if you might have 10 liens filed by service providers that add up to $1 million. And that was the point David was making. If we can knock out 3 or 4 of them, now you, instead of being 100,000 out of $1 million in liens, you may end up being 100,000 out of 200,000 or 300,000 because everybody else did it wrong. And that happens.
And then say it gets resolved, is everybody paid an equal amount, or is it based on how much is owed to them, or?
Well, in bankruptcy, it could be pro rata, okay? If you're lucky, you know, there'll be a pot of money and it's split up among the lien claimants in proportion to their percentage of the total lien claims, valid lien claims.
If there's no bankruptcy, sometimes the squeaky wheel gets the grease. But, you know, and the squeaky wheel might also be pointing out to the debtor, the operator, that these two liens are invalid. You don't have to worry about them. You know, you gotta worry about me. And we have some case examples of that.
So this is kind of available to, as we were talking about before, where you have a new operator come in and the well is leaned. This might be a remedy available to them in order to get the money flowing from the well again. They can post bond for 125% of the face amount of the claimant's privilege, and that'll that way you can get money flowing from the purchaser and everything again.
The important thing there is what does that mean to me? All right, well, that means that instead of looking to the cash flow off of the well site, you're looking to a bond from surety, okay, and the bond's held by the clerk of court. You're still going to have a little lawsuit to decide whether that bond should be, should pay over to you against your lien. But in the meantime, the operator can run the well and receive normal production payments without having everything tied up while we sort through, whether the liens are valid or not.
Generally, the time that you see a bond posted is when the operator is convinced that he has defenses to the lien claim. So he wants to litigate the lien claims, or he's got the financial ability to litigate and throw up defenses to the bond claim, to the lien claims, in hopes that you settle for whatever everybody decides is appropriate, whether it's 50 cents on the dollar, 80 cents on the dollar, whatever.
I'm gonna let Army talk about the bankruptcy part. That's his forte.
Yeah, you won't hear me say anything about that.
I do a lot of work on this statement, on this slide, but bankruptcy, that's a bad situation. What will happen in a case like that is, there's a limited amount of money, and even secured claims are not always paid in full. So it becomes doubly important that any privilege claims be valid, and that you take the proper steps to maintain your position, maintain the perfection that you have in a privilege. Sometimes, and this gets down into the nuances a little bit, but one of the features of a bankruptcy is what's called the automatic stay. And if you do any kind of credit work, that's one thing. Two words you're going to want to know about bankruptcy. It's like a giant gate that comes down and blocks any collection efforts against a debtor once the petition has been filed. You have to stop everything in your efforts to collect money from the debtor unless you have court approval. Now, there's some very limited exceptions to that, and here's where a bankruptcy or where a lien privilege can actually be a good thing as well. Let's say that somebody owes you money. You're worried about them. You're going to get ready to file a lien, and last Friday you learned that they filed bankruptcy. What now? If your goods and services were provided before the bankruptcy filing itself, you have the ability to go out and file that lien, and you will not be violating the automatic stay provisions of the bankruptcy code. You have to do it in the same form that you would otherwise. And then you think, well, all right, but now I've got a year to go on this privilege. I'm going to have to sue them, and I can't sue them because of the bankruptcy case. You can actually, instead of filing a lawsuit to perfect your lien, what you can do then is file it's called a 546B notice. It's basically a notice to the world via the court that says, I intend to enforce my rights in bankruptcy on this lien. And that will preserve your claim. You You still have to file a list pendants in the public records, but that's not a violation of the record study. A note about what's called secured credit and what's not. In bankruptcy, what happens is you always have a limited amount of money and there's not enough to go around. So we get into questions of pro rata distribution and a whole lot of questions about perfection. Is the lien valid? Yes or no? And if it's not, it doesn't participate. Most often in bankruptcy, if you're unsecured, it's a sad story. I mean, very, very seldom will you see much in the way of recovery beyond, say, maybe 5 or 10 cents on the dollar. And more often than not, nothing. So I guess the word I would say there is that if you're in a situation where you feel like you have a privilege, or maybe you filed one and there's an intervening bankruptcy, probably the best thing to do is to call counsel. Contact an attorney that can help you out. Certainly, we'd be glad to. But there are many people that can. And it's not fatal to your efforts to collect on a privilege, but there's some special things that have to be done in order to preserve your rights in the bankruptcy context. Invoicing procedures, I think, the question, we touched on this throughout the talk a little bit, but, on the front end, it's very important that you guys, anybody who is providing goods and services to a well site, have as much information as they can on the delivery tickets, on the invoices, and you're trying to establish a chain of activity that you can prove without having to go to a courtroom to prove it. You can at least prove it based on signed documents. I think it's important also to have a protocol in place so that it says, all right, my payment terms, I expect to be paid within 45 to 60 days. If we hit day 75 and I haven't been paid, this is what I'm going to do. I'm going to send a letter out. If I hit to day 90, maybe I'm going to call my attorney. And if I get to day 120, we better be talking about filing a lien. Do not wait until day 173 to call us and file a lien. And I mean, this happens all the time, but it's very difficult, and it can be expensive to any provider of goods and services if at the last minute you have to race around with attorneys and searching court and land records to make sure that you've got the right information. Better to do it on the front end and do it with sufficient time that we can get it done right and economically.
The other thing that's going to happen if you wait 70 days to get going is you're going to be telling the operator, okay, I need to look and see if they really provided this within 180 days. If you file timely, this is close, and then you're going to spend more money to prove that in fact you filed timely. If you file it 150 days, anybody can look at the invoice and it's going to be, they filed timely.
Yeah, I think when you file the lien document itself, it's one of the ways you can kind of make your life easy is to actually attach copies of your invoices and delivery tickets even to the lien, because then you're telling the world, I got nothing to hide here. This is a legitimate lien. It was timely filed, and I've got the proof. Otherwise, you're inviting somebody to contest it, and when that happens, you end up having to spend money on legal fees that you wouldn't otherwise have to spend. And for the folks who are who might be receiving a lien, it's the same thing, but in reverse. You start to receive, if you have a series of liens filed against your well site or any, you're going to want to look under the hood of that lien and see, have they followed the statutory prerequisites and putting the lien document together? Take a look at the times. Was it valid? A lot of people mess up. And if they do, then, you're not dealing with a lien, but you're dealing with a claim on open account. These are some good examples. This is one of Sam's favorite slides. We had a case pending in the Eastern District of Louisiana. We represented a debtor. there, and, or actually the trustee, the bankruptcy trustee. There were a number of liens filed. I think the liens filed were in excess of $3.5 million against a series of wells. And it was a lawsuit among all the lien claimants, and they were trying to fight and say who was right and who was wrong, who should participate in the amount of money that was being distributed out. I did an evaluation of these liens, and here's how it shook out. 2 of them were ruled unsecured because they failed to timely file a notice of privilege. 8 for almost $850,000, a little over $850,000, were ruled unsecured because they failed to file a lawsuit or a notice with the bankruptcy court within that 1-year period they were supposed to take. And this was killer. One privilege, $1.2 million, was ruled subordinate to all the other claims. In other words, they didn't get paid because they didn't file a notice of those payments in time. Huge.
One piece of paper.
One piece of paper cost you $40 to file.
Cost them $1.2 million to pay to file a 8.5 by 11-inch sheet of paper with 3 sentences on it in the courthouse.
Terrebonne Parish, we represented a working interest owner? Non-operating working interest owner. There were 15 demands on loan and privilege claims filed. They totaled almost $1.5 million. We did an evaluation of them. 6 of them were ineligible because they never filed privilege claims themselves. 2 of them, over $150,000, were not timely filed. 5, over $205,000 for failure to file an enforcement suit in time. And 2 of them for over $700,000 were invalid because they didn't file that single piece of paper.
And I'm trying to remember.
We knocked them all out.
No, there were 0 legitimate liens filed in this case. $1.5 million.
Yeah. So you look at
15 people tried, and all 15 screwed up. And this was a situation where we were representing the non-operators who had responded to the AFE and actually put up their money and paid to drill the well. And the operator, I'll say maybe the operator perhaps was a crook, and took some of the money and didn't pay the people who provided services to the well. So we came in for the non-operators and we said, sorry guys, these are all invalid. Your only claim now is against the operator who was the crook.
that was a really great story for the non-operating working interest owner. Blackman Parish recently, I had a case where we looked at 9 different privilege claims, total a little over $1.6 million. 4 of them, almost $1.2 million, invalid because the privileges were filed at 182 and 183 days instead of 180.
Sloppy.
So that's the same slide we talked about earlier, the time schedules for liens. Lien is a powerful tool. Just you got to pay attention to the time. You got to pay attention to the form, and we'd be happy to help you do any of those things, whether you are filing claims or defending against them. And so with that, take any questions that you guys may have. Yes.
That's a question that might not pertain, but tell me if it doesn't, I can talk to you about it. As far as up front, getting ready to perform services, in our case, drilling the well. And you have a contract, and the contract says the operator can put so much money into a escrow. We found out many times what's happened to us a lot is you're on the well, you run past the amount of money that's in the escrow, you ask for more money. Oh yeah, we'll put more money in there. They don't. Finish the well, get paid the amount that you had in escrow, but you're still over a certain amount. Well, we don't really have any more money because we couldn't get our investors to give us any more money. I mean, is there anything we can do to make that escrow clause contract more firm? Like say, you don't put any more money in here, I'm going to stop drilling as well. Something like that. Have you ever come up with it?
have your lien rights. And I would just add a sentence or two to your escrow clause. I've seen the clauses you're talking about. That says, you know, in the event that this is just an estimate, and that if we overrun it, we need the escrow to be refunded, and we'll invoice you, and you've got 3 days, 5 days, whatever you think is appropriate to fund that escrow, or we have to shut down operations. And if you're willing to, you know, you're gonna make the decision whether you're gonna enforce that clause when the time comes. But you certainly could add that, you know, to your provision and protect yourself in that regard. Tell them what's gonna happen. I'm gonna send you an invoice, and you got 5 days to fund it. If you don't fund it in 5 days, we have the right to shut down operations.
Would you want to write anything in there that says, I don't know, we have the right to shut down operations, but all, you know, we're free of all risk involved with shutting down operations? You know,
You know, the IEDC,
shut down something and then.
that IEDC contract pretty much protects you anyway.
Yeah, I
You
know.
That's a tough agreement.
And the good thing there is
When you look at that,
you can always blame us too. You know, I mean, hey, look, it ain't me, it's my attorney. You know, we got to do that. And I would do the thing you're talking about, you know, on the front end while everybody still smiles and handshakes before things go awry. Yes, sir.
Say for instance, you're going out, you're doing some work, you're being contacted by somebody, and you know these people, so you don't have to go and do your whole due diligence on and find everything out about them. You get everything from the operator, all the forms and everything. They'll say on the letterhead, this person you're doing the work for. Then, when it comes to my payment, they know it's from the exploration company. And this exploration company did this many projects, and they're all unsuccessful. We're dissolved, but the bigger, larger operating company is not liable for it.
No.
The operating that's on the wells, the operator is the one who takes the.
The lease is the one that takes where the privilege goes. So, you know, you may be, you've got Tom, Dick, and Harry here, and you're dealing, you think,
Yeah.
with Tom, but then you get paid by Harry, who has no interest in the well. If you're not paid, you still have provided services directly to the well site.
yeah, you now have 2 claims. You can file your lien against the well that you provided services for, and whoever you contracted with, you have a contract claim against them on open account.
So the evidence of that you have a contract with them would be from a signed ticket on to the operator, which you know would say that, and then all the documentation that they had sent you. Would that be evidence that that's who you had the agreement with, not this?
In the case of a well, what you're proving, or a privilege, what you're proving is an unpaid bill for goods and services delivered to the well site. Okay, doesn't necessarily matter whose letterhead is at the top of the check or you know, the purchase order on that. If you've delivered them to the site and if you properly notified the operator of your claim, your privilege is going to survive. Yes, sir.
Are you able to sell your rights to a lien once you filed it?
Yeah, I think you can. Sure, you can assign it just the same way I might assign an account receivable to you or anybody else.
But if you do that, you need to do it before the lawsuit's filed. Because if you then transfer your rights once the lawsuit's filed, that's the sale of a litigious right. And it can be retired or an obligation to pay $100,000. If you buy the company for $5,000 and it's a $50,000 claim, if you buy it after the lawsuit is filed, they can give you $5,000 plus interest, if I recall correctly, and the obligation is wiped out because that's all you paid for. But if you make the transaction before the lawsuit is filed, you know, you got a $100,000 claim, even though you only paid $5,000 for it.
Thanks, guys. Appreciate it.